Hello and welcome to Law and Democracy, a podcast of the election law program at The Ohio State University. I'm Steve Huffner, the Deputy Director of our election law program. And in today's episode, I'm delighted to have with us not only Ned Foley, the Director of our election law program, and Tony Goggin, who is the current family professor at Drake University Law School and a senior fellow with us at Election Law at Moritz, but as a guest today, Derek Muller, who is a professor of law at the Notre Dame College of Law. And Derek, welcome. Great to have you.
Thank you for having me.
So, Tony, where do we want to get started today?
Well, Steve, our first question for Derek is this. Derek, as an election law scholar, what surprised you, if anything, about the 2024 election?
Maybe what surprised me is how normal it was. I think there was lots of fear going into this election. I spent countless hours talking with countless reporters, going through all kinds of disaster scenarios, and I kept saying things like, "This is not going to happen. A state will not miss a deadline to certify its results. The state will not just refuse to send its electoral slate into Congress." There are all these kinds of hypotheticals, and everyone was worried about. And over the years, I think we forget that so much of what was fearful about 2020, it wasn't just the sort of recounts and riots that happened at the end. The things that were leading up to the 2020 election were challenges relating to the COVID pandemic and those dramatic changes that we had to our rules, the dramatic litigation over those, whether states should have changed their rules, whether states shouldn't have changed their rules, whatever it was. In addition to the fact that we were physically separated from one another as human beings for months and months and months leading up to that election. So there were lots of bad things that came out of that situation, just societally, setting aside the political and the election law related stuff. So there were lots of bad things in 2020. And so when we worried about what's going to happen to the polls, how are poll workers going to react, we've seen elections in the primaries in general in 21, 22, 23, and things worked pretty well. So we get to 24 and things worked pretty well. The system held quite well. Now, part of that, I think we could say, is attributable to the fact that it's wide margins, right? Former President Trump won pretty decisively in the Electoral College, pretty decisively in every state. So we don't have the sort of questions about whether or not we need to have this batch of ballots here, that batch of ballots there counted or not counted or whatever it might be. So we're in a different situation than we were in 2020. So there's a lot more stability and preparation that went into 24. There was a lot of just administrative changes that states made, whether it was being able to expedite counting of absentee ballots or increasing transparency of certain things, whatever it might be, lessons they learned from 2020. And then, the fortune of having wide margins. So we get to the end of it, and it's I think, pretty ordinary process, pretty ordinary election. I think election day went off largely as expected. And so I'm grateful for that. And again, grateful for a return to some normalcy in the election law space.
Derek, do you think that's, you obviously mentioned the wide margins. Do you think this means we're sort of out of the woods for the future? Or we have to, 2 years in from now, or especially 4 years from now, be fearful that if you get a really close election, we will be back in the woods having to worry about these things?
I think we're always going to have to be worried about close margins. As you know, Ned, that election of 1876 was a nightmare because of how close it was. We can talk about the election of 2000, which was a nightmare just because of how close it was. And again, you're setting aside, these are not necessarily polarizing candidates in any particular way. I'd say in 2000, these are two candidates that rode to the center as hard as they could, as two candidates in the modern era might do. But it's just when it's so close, it just heightens every mistake. It heightens every choice. The layout of the ballot in 2000, right? The choice to use punch cards, what you do in one county as opposed to another county. There are just so many little things. And when the margins are wide, we don't mind them so much. And if there are fights over, we'll probably talk about Pennsylvania, right? We're talking about absentee ballots in Pennsylvania that are missing a date, and we're talking about 400 ballots here, 600 ballots there. it doesn't matter when the margin is 17,000 in the Senate race and tens of thousands more in the presidential race, right? It really matters if the margin is 200 votes. And so again, setting aside even anything nefarious or anything that we worry about, the point is the very close margins you just can't prepare for. You really can't, because there's just too many moving pieces in our election system to be able to adequately address and handle that. So we hope that we can have as much confidence and transparency in the process going into it so that people feel confident about the back end. But at the same time, when the stakes are so high and the margin's so slim, I think that's a very hard thing to prepare or brace for.
Since you mentioned Pennsylvania, do you mind my asking what you make of the fact that that some lower courts in Pennsylvania basically refused to follow the directive of the state Supreme Court and needed to be reminded that the state Supreme Court is controlling authority here? I mean, I was sort of flabbergasted myself that we could sort of see this disobedience, but am I missing something about what's been going on?
It was mainly election workers.
Yeah, it wasn't really the courts. It was election administrators, right?
Yeah, fair, yes.
Yeah, but yeah, so to set this up, right? So heading into the election, there have long been questions in Pennsylvania about what we do with things like undated ballots, right? Among other things, that ballots missing signatures and other stuff, but especially undated ballots. So going into the election, a lower court in Pennsylvania issued an order saying, hey, we think that this violates our state's constitution's free and fair elections clause to not count these kinds of ballots. And then the day before the election, effectively, the Pennsylvania Supreme Court unanimously issues an order saying, no, you can't change that rule. And again, you're looking back, it's dealing with a past election, but knowing that it's prepping and teeing up a case for the 2024 election, saying, and it will not apply, that case, that precedent will not apply for the November 5th, 2024 election. So you have a pretty clear guidance from the Pennsylvania Supreme Court in a unanimous per curiam decision saying, whatever you're litigating about with respect to these ballots, not going to apply. And then you have these county officials that are asked to count the ballots. Lawyers for Bob Casey, for the Democratic candidate who's trailing in Pennsylvania and looking for an opportunity to get ahead, like saying, well, these ballots should be counted. And the argument there being as well, I mean, when you're not technically bound because that was a different case at a different time, and we're now the Casey campaign as opposed to the other campaign. That was a procedural case, and we said that it's supposed to be without prejudice. Like the claims were made without prejudice, which means we can come back and relitigate them at a later date. This is the later date. We want to relitigate them. Now, those are good arguments to make in front of a court, to go to a court and say, I know that in the past you said these ballots shouldn't be counted, but now we're supposed to count them. But you have election officials in these counties, again, along partisan lines, and that's the unfortunate divide here, saying things like, people violate laws anytime they want. So for me, if I violate this law, it's because I want a court to pay attention. That's not a good statement. I know that this commissioner in Bucks County, Pennsylvania in particular, tried to backtrack and saying, well, it's taken out of context. So I'm not sure a context in which that would be a good use of the phrase, people violate laws anytime they want. And if I violate it, I want a court to pay attention. So there does seem to be kind of this overt defiance from some of these election officials. So it's not just kind of say, well, it was procedural and, well, it was a different case, but something like, we just fundamentally disagree with the Pennsylvania Supreme Court here. And if they really want us to not count them, they're going to have to say it again. And then which they did this week. The Republican National Committee went there, try to seek the King's Bench's extraordinary jurisdiction. And I'm not an expert in the extraordinary jurisdiction standards in Pennsylvania. But when you have such defiant conduct from lower level election administrators, the notion from the RNC of saying, look, we're not going to do this piecemeal, county by county through the state. Like, let's just get the Pennsylvania Supreme Court to issue one order for all of these counties so that the ballots will not be counted consistent with the existing court rule and the existing understanding. Now, in theory, in 2026, you might have a majority of that Pennsylvania Supreme Court still come back and say, well, the free and fair elections clause at the end of the day does say they should be counted. But we haven't gotten to that point. and maybe it's coming, but they weren't supposed to be counted in this election. Again, that's what I think that's what we want. We don't want kind of the after the election making these judgments when we know whether Democrats or Republicans are ahead and who's going to be advantaged by changes in the rules where we said we weren't going to count them before, but now we're going to count them. So it's a very unfortunate and messy situation in Pennsylvania. Setting aside whether or not it was jurisdictionally appropriate for King's Bench extraordinary jurisdiction, it was a swift reprisal, and that's, I think, what we want to see: courts swiftly ending these kinds of decisions by local election boards that shouldn't have been made.
In a way, Derek, I was just going to add, in a way, is Pennsylvania the exception that proves the rule that 2024 was an exceptionally smoothly run election? And certainly, as you point out, Derek, the large margins are critical in the presidential race. However, we've got lots of close races around the country. In your former district you used to live in Iowa, there's a few hundred votes separating the candidates, or lots of state races around the country that have single digits or 15, 20 votes separating candidates. And yet we're not seeing this Bucks County, Philadelphia County issue, I think, is so striking because it is so unique in an election where 153 plus million ballots were cast. This is really the only instance I'm aware of where we've seen election officials who've really gone off the rails.
Yeah, so far that's right, and that's encouraging. In North Carolina, we have a state Supreme Court justice race right now where one candidate is ahead by several hundred votes. Iowa's first congressional district, as Tony mentioned, I was involved in that recount in 2020. It was a margin certified by 6 votes. Right now, it's an 801 vote margin, so that's a landslide. Comparatively, they're going to a recount. There are recounts happening in the state of Maine right now with a lot of state legislative races decided by double digits, in the teens. There's a congressional election in Orange County right now where a Democrat is ahead of a Republican incumbent by a couple hundred votes with still more ballots to count. So, but this is ordinary, right? Throughout the United States, you're going to see close elections, but you're not seeing that kind of pitched fever. And so it's really something about Pennsylvania uniquely, because these battles have been fought now for about going on 6 years. And you have a legislature that's on notice and an executive on notice and an inability to bargain a solution. And so this litigation has been constantly playing out with no definitive solution in sight. And it's exacerbated by Pennsylvania having not only a closely divided electorate and a very high number of electoral votes at stake, and here obviously a crucial Senate seat for whether you have 52 or 53 votes for Republicans in terms of defections and a various number of issues. But it's a state where you have significant local control, some of the most local control in the United States. So you've got 67 counties that have a lot of autonomy, and it's very hard for the Secretary of State to corral them to do anything, unlike in other states where you have a lot more centralization. So it's long been the perfect storm for this kind of litigation. And this case, I mean, these ballots are not going to change the outcome of the election. Like, whatever is being contested right now, it's a few hundred ballots. And McCormick is up on Casey in that Senate election by 17,000. Like, we're not even talking about a margin that's going to change. It's just the latest in a proxy war for these sorts of fights that have been happening for years in the past about Democrats trying to sort of broadly construe the rules under the free and fair elections clause, the state constitution, to allow more ballots to be counted, and Republicans who are insisting that the rule of law demands an adherence to the statutory code as the legislature interpreted it, and so these ballots shouldn't be counted. And it's just the same iterations year after year in the state of Pennsylvania.
Can I ask a follow-up that relates to the local control you mentioned, Derek, in Pennsylvania in particular, which is whether we know how many local counties in Pennsylvania have, in fact, in the recent past, not this election, but in recent past elections, counted exactly this type of ballot on the basis that even though the date is missing, the ballot has arrived before election day, so they know that in some sense it's not a fraudulent ballot, even though it's not in technical compliance. And have counties, some places, been counting just that kind of ballot before, and that's partly why they insist they want to keep doing it?
So I don't know. I feel like there are so many issues in Pennsylvania about naked ballots, ballots lacking signatures, timeliness of acceptance of ballots. that I'm not sure which which counties have done what at various points in time and whether or not there have been successful efforts on it. But I do know there have been divergent approaches, and sometimes I've seen, and I can't remember the particular context, but one of the lawsuits was pointing out that there were 12 different approaches across the 67 jurisdictions for handling ballot in terms of how they would contact voters who are missing information in order to cure it. And that's a lot more flexible than the decision to count or not to count, right? But I think it highlights the wide disparities you have in Pennsylvania, that there's just an inability to corral. It's left to local rule, and there's just inconsistency, as we've seen, at least sometimes.
Well, and the real point, as I took it, of this Pennsylvania Supreme Court decision just before Election Day was, to the extent the state constitution, the Commonwealth Constitution, is going to determine whether this type of ballot is countable or not, that is a decision that ought to occur not in the heat of an election, not,
Yeah.
It's kind of a Purcell principle at the state level. We're not going to do that now, but I think that ought to mean that we shouldn't wait till 2026 either, as you mentioned, Derek. This is something that we ought to see Pennsylvania figure out in 2025 or something.
Yeah. Well, but again, I'm sure in 2025 there will be special elections or local elections or things like that that could also be affected. I mean, there's always this is always the tension, right? There's always another election coming down the road. The question is how quickly you can tee up a case to be able to resolve it, and why the judiciary is such a poor place to resolve these things. When you have a transparently problematic set of rules that just need some kind of guidance, it's the place you want the legislature. And I understand the argument, if the free and fair elections clause demands that these ballots should be counted, that puts the judiciary in a really significant place to make those kinds of determinations. But there are probably ways for the legislature to be able to step in there and either be much clearer about it, to articulate why it matters to have the dates on there, what kinds of information it can be used to get, and so on. But once you're putting it all in the judiciary and saying, hey, judiciary, you need to do this under a very abstract principle of free and fair elections, in a way that the judiciary has traditionally never been involved in enforcing that provision for this level of election administration, just puts the judiciary in a very difficult place.
Derek, one of the other striking features of the 2024 election was the fact that it was the least racially polarized election the United States has seen in decades. What do you think the future of racial gerrymandering claims are in an era when it appears now that we don't have racial polarization with regard to Asian American and Latino American voters? Both parties are actively campaigning for their votes, and it appears that the Republicans may have won as much as, in many jurisdictions, as much as 20% of African American votes, which, while still a small percentage, represents a very significant move in the Republicans' direction. So what do you think the future of racial gerrymandering claims will be in this country?
Oof. This is a big question about figuring out, and especially I think I could talk a little maybe more about the Voting Rights Act side than the racial gerrymandering side, although they sort of end up being flip sides of how sometimes these things are litigated. I think when we think about redistricting and drawing congressional districts, state legislative districts, whatever they might be, one of those salient features, that all of us have taught in our election law classes is focusing on Section 2 of the Voting Rights Act and talking about that sort of standard from Thornburg versus Jingles in 1986 and the kind of hallmarks that we need to be able to ensure that there is a majority-minority district and to be able to enfranchise a cohesive group of racial minorities to be able to elect the preferred candidate of their choice. And that test, right, it has a number of factors. And one of the crucial components is that this minority group, the racial minority, must be able to show that it is politically cohesive. And that language from Thornburg, the suggestion that you're politically cohesive, is to suggest that you have this relationship between the minority group and the majority group, typically white voters, right? And the minority group is cohesive and its choices are consistently thwarted by the majority. So when you have that kind of polarization, you're able to draw a district for the minority group. But you can look at the 2024 election and say, what if that polarization has dissipated? Right, especially, and let's pick on Texas for a moment, and we can talk about the Latino population in Texas, especially southern districts along the border, where they are heavily Republican now in ways that they were not 10 years ago. And so now you're looking at those districts in Texas, and you're wondering, boy, are these districts, are some of which we've drawn in the past, consistent with Section 2 of the Voting Rights Act? Are these things required anymore? And Professor Nick Stephanopoulos at Harvard has a recent article talking about some of these changes that are happening and thinking about Section 2 as kind of being paradigmatic about ways that we might have to rethink some of these issues. Because if we draw the districts in a way where we assume the Latino voters typically supported Democrats and the white voters typically supported Republicans, and now we go back and say, wait a minute, no, they're supporting Republicans at much closer to parity or at similar rates or whatever they are, then suddenly those justifications for the Section 2 districts fall away. And then maybe for Texas's sake, maybe people show up and say, hey, now we've got a racial gerrymander because we drew these districts on the basis of race for Latino voters, but we didn't have to. We don't have to anymore because circumstances have changed. And if we drew them on the basis of race consistent with Section 2 of the Voting Rights Act, but it's no longer consistent with Section 2 of the Voting Rights Act, then maybe we've inappropriately drawn these districts. So I don't know what happens on the legislative side about how the judgments are made in the legislature about which districts you're drawing, how much you're taking race into account for them, whether or not you need to redraw districts because you previously drawn them on basis of race to be consistent with Section 2, and now you don't have to anymore. And we also have to ask ourselves about not just politically cohesive, but there's some suggestion that they usually are defeated by white voters. Their preferences are usually defeated. So there has to be some kind of consistency or longevity to the ability to succeed. But we can see the trend is moving more and more favorably in Republicans' direction over the years from 2020 to 2024, from 2016 to 2020 to 2024. So I don't know. I think there's a major shakeup that may be coming, especially I'll be watching jurisdictions like Texas to see if there's going to be litigation over this, new maps, or whether we're just going to wait and hold off for a new way of drawing the districts in 2030. I don't know. But this election, I think, at least in pockets of the country, is going to be pretty remarkable for thinking about redistricting going forward.
It seems like the empirical questions there can get pretty tricky. It feels like it would be hard to say that a district drawn for purposes of Section 2 that was properly drawn at some previous time that no longer can be justified because of the way in which the previously racially polarized electorate is no longer racially polarized, was therefore improperly drawn when it was first drawn. It's more a question of whether it's improperly not redrawn now. And then that requires you to really start figuring out at what point, as an empirical matter, the underlying demographics and racially polarized voting has changed enough. And it starts to remind me of some of the empirical issues that we saw being litigated in the partisan gerrymandering context when we were trying to figure out whether there were empirical ways of identifying when there was too much partisanship. And it's one thing to just conclude that a particular set of districts is preventing a particular racial minority group from being able to elect the candidate of their choice. But to be able to say now that that is no longer sufficiently true, I think seems like a harder empirical problem.
I would think it would be, assuming that the district was properly created under the Voting Rights Act when it was created, it seems to me it's a sufficient defense to any challenge that status quo and stability justifies keeping the lines. That's not racially motivated decision making. That's motivated by other values, and so and I don't think there's a need to redraw until you get new census data in 2030, and then have to potentially redraw for one person, one vote. And the only other thing I'd say quickly is it seems to me it's a very healthy development in our society if racially polarized voting diminishes.
Yeah.
We should applaud this as a good thing. We're still going to have electoral contestation among the parties on various issues, whether it's economic policy or environmental policy and so forth. And so, you know, the fact that we don't need to worry about, you know, representational fairness because of one racial group dominating, you know, to the point of really denying another racial group political power, you know, that's an important development in American history. Now, again, I think we shouldn't jump too quickly to the conclusion of the fact that we're seeing healthy depolarization in some respects, and starting green shoots in other respects doesn't mean we're all the way there yet. I mean,
Yeah.
I think we're going to have to worry about Black representation being subject to vote dilution for another decade or so, and be sensitive to that.
Yeah. Yeah, I think so. It's well taken, Stephen, that on this point. But Steve, I think there is a kernel of truth there, thinking about the partisan gerrymandering and how courts have sometimes, after 2, 4, 6 years, and this was sort of the record in Gill versus Whitford, again, unsuccessful on the federal side, but you might see it in the state courts play out in a different way, right? That after a period of time, we look at the map in that decennial redistricting cycle and say, wait a minute, now that we're a few cycles in, we see there's a significant problem in terms of the partisan gerrymandering that happened in that map. We now have that evidentiary record, and so we can step in and order a remedy. Not a perfect analogy, but a way of thinking about it. The other is, and I'm not sure what the Supreme Court would say about this, but you know, Section 2 is designedly dynamic because it's responsive to current events. It requires you to show in the current redistricting cycle that there is this racial polarization and whatever it might be. You know, we've never had a situation, I think, where it's been so dramatic a change in racial polarization in a short period of time that we might second guess the maps that we had previously enacted. I come back to the line from Northwest Austin, and I know that was a Section 4, Section 5 case, not a Section 2, but the language in Northwest Austin, repeated in Shelby County, current burdens must be justified by current needs. And if we're saying that we need to draw the districts in a particular way, that needs to be current and necessary going forward. Now, maybe, Ned, you're right that the point is for the stability of the electoral map, and the reason we don't like interim redistricting in the middle of a 10-year cycle, absent something extraordinary that's a change of events, maybe a substantive change in the law or whatever it might be. The judgments we made in 2021 and 2022 should carry us through 2030. Maybe that's right. But I think, to Steve's point, I think the evidentiary question is going to be an interesting one, whether or not something happens in the short term. But I think it's certainly going to be a major question on the horizon in 2030.
And it's truly historic. The last time we saw a change, demographic change in partisan allegiances, this sweeping, was the 1930s, when African Americans who had voted for the Republican Party in every election from Abraham Lincoln through Herbert Hoover. In fact, in 1932, the best evidence we have is Hoover carried a majority of African Americans. But then in 1936, FDR became the first Democrat to win a majority of African American voters nationwide. And by the 40s, Democrats had a virtual monopoly in many parts of the country on African American voters. So that was also a period of rapid change. But we've seen nothing like it in 90 years, which is amazing to think about. Well, speaking of historic changes, there's also been another historic change in the 2010s and 2020s, especially the 2020s, Derek, and that's in the arena of campaign finance, where historically Republicans greatly outraised Democrats in the late 19th century, throughout the 20th century, and into the early 21st century. But now we have seen in the last several election cycles, Democrats greatly outraise Republicans, and super PACs, which are a much less efficient way to raise and spend money, are really the only place where Republicans are still competitive. What do you think that says with regard to the future of campaign finance as an issue of debate and public policy discussion in the years ahead?
Yeah, it's been definitely a shift, right? So in 2008, when Barack Obama opted out of public financing and essentially doubled John McCain's spending, I mean, Democrats have dramatically outraised and outspent Republicans in every election since every presidential election since 5 consecutive elections where Democrats have had a 9-figure edge. That's a substantial amount of money, and maybe this year a 10-figure edge. And it's interesting that Republicans have long sort of advocated for opening up the amount of money to spend, and the sort of the conventional wisdom was, well, their wealthier donors are going to support Republican causes. There's more money there. And the exact opposite has been the case. Democrats have raised a lot more money. And even with the super PACs, as you mentioned, Tony, Mitt Romney and this cycle, Republicans are going to get closer to holding serve, but there's still, $1 billion in super PAC money out there for Democrats as well this cycle. It's not just it's not just a Republican thing. So I think I don't know that there's necessarily assumptions about who's going to benefit. It really requires kind of one or a handful of donors who are passionate about this. And I think we saw Elon Musk suddenly realize, I should give $200 million in a very short period of time. It doesn't take much to move in that direction. And others that Democrats have long praised their ability to sort of fundraise from small money donors. Act Blue was a very early sort of opportunity for sort of Democrats to be able to raise money in small figures, sort of microfinancing, micro-targeting, and a broad base of donors that have been brought in. And so it's not just big donors that are giving to the super PACs. It's also small money donors and more regular donors that are giving. WinRed, sort of the analog to Act Blue for Republicans, has come online, and but it was a little bit later to the party. So it's interesting to think about where the money is. I think we're seeing also part of the shifting alliances in the last decade has been shifting socioeconomic status, where Democrats have increasingly been relying on wealthier voters, and Republicans shifting toward more working class voters. How much that relates to the campaign finance piece and where the donations are coming from is its own separate interesting challenge. And we have candidates who are wealthy but didn't self-fund. I mean, so Mitt Romney, while he famously self-funded for his 2008 primary, which was fatal, didn't really spend his own money in 2012. Donald Trump paid off some primary debt in 2016, but really didn't spend any of his own money in 2016 or 2020 or 2024. So despite being often having wealthy individuals at the helm as your nominee, they're not spending the money as the candidate. So I don't know, that's just a lot of observations without sort of figuring out the way forward. It's just a tremendous amount of money that's being spent. I think one question is how efficient it is. At some point, the marginal value of the dollar diminishes. There's only so many advertisements you can buy. There's only so many doors you can knock on. There's only so many yard signs you can put up. I think people are constantly trying to use that money instead for data analytics, or trying to figure out how we can increasingly determine the value of it. I think the Harris campaign spent more than $100 million just in advertisements to solicit money. And that's a lot of money to get money. So that's a tremendous, it ends up kind of being this flywheel of when you spend the money to raise the money. But I'm increasingly interested in some kind of political science about trying to figure out the efficacy of spending the money and the diminishing marginal returns on the exceedingly large sums that we're seeing in these elections.
That last point runs counter to a lot of the traditional explanations about how much is being spent, which was that cycle after cycle, candidates and their campaigns felt this pressure to outdo their competition from the last round. And there was this kind of ratchet effect that the amount of money being spent in the political process was increasing always much more rapidly than inflation. As each cycle, people found new kinds of things that they thought might work. And the question you then raised, Eric, is have we reached the peak? Are we at a point, and maybe social media is playing a role here too, where the returns are diminishing? I have no idea whether that's true, but that's an interesting possibility.
Yeah, it's just hard to know. I think there's so much earned media that people can get in diverse ways, and I think we've seen some of the when candidates show up on long form podcasts that get millions of hits, podcasts like this one that get millions of hits, right? Now, that's a very low cost for the campaign and gets a lot of exposure, and it's very different than holding a traditional rally out in public with hundreds or thousands of people that show up and wait in line for several hours, and then you have to have all the security detail and the rentals of facilities. And obviously, we know from the assassination attempt that former President Trump faced, the security is much higher now, and all the exhaustive processes that should go into these things. So you have gobs of consultants that are willing to take money on things. The question is what value there. And you have gobs of lawyers that are willing to spend money on things and sort of help prepare you for worst case scenarios, or draft white papers, or be on standby for things. But yeah, what's the money going toward, and is it useful, or how much sort of non-traditional avenues of whether it's running a campaign or whatever it might be valuable. But see, I think that the constant desire to raise more money is just omnipresent, and that once you need to raise it and then you need to spend it. And there's very little assessment until after the election. I don't know how much institutional memory there is about what worked and what didn't work from one campaign to the next.
Well, and it's still true that most members of Congress spend and have to spend an inordinate amount of their time in fundraising.
Yeah.
But can I ask a follow-up to the empirical claim that, Tony, you started with about the Democrats outspending Republicans? That was specifically with respect to the presidential race, or with all federal races, or?
Yeah, the presidential race, I haven't looked at the latest FEC number. It's hard to compare apples to apples to a certain extent in the Senate races, where there are only a handful of competitive races, and yet you still have a lot of members of Congress who raise money when they're not in a competitive race. But certainly from the presidential, the Democrats had a huge advantage when it came to direct contributions to the candidate campaigns. And because of the lowest unit charge rule, the candidate campaigns get discounted pricing for TV and radio broadcasts. So that money goes so much farther than super PAC money goes, which is a really interesting issue that kind of flies beneath the radar. But it's why I think every local TV station in America loves super PACs, because they're charging them the same rates that they charge car dealerships.
Well, and the other empirical question I found myself wondering about, and it is much harder to unpack, is what's happening at the state level with respect to the two major political parties. And of course, that's harder to unpack, in part because what the campaign finance laws are in any given state varies quite a bit from jurisdiction to jurisdiction. But I would be curious to know whether what we have seen happening in the presidential race is happening in very many other state and local races or not.
One state worth watching is Wisconsin. It's off the top of my head, but I believe Wisconsin eliminated contribution limits when they had a Republican governor, Republican legislature. They have a Democratic governor now. It'd be very interesting to see if Republicans retake the governor's mansion in Madison and control the legislature, whether they would consider reinstituting contribution limits if the Democrats have an advantage with suburban voters backing them, and as Derek said, wealthier voters moving towards the Democrats. Maybe we will see at the state level the first significant campaign finance regulation promoted by Republicans.
I mean, maybe we'll see that. Again, this is the interesting thing, right? That Republicans have long sort of advocated for sort of the free speech side of things, the unlimited spending, whatever it might be, but have clearly been on the short side of some of the spending. And talking about Wisconsin in particular, they had a very contested state Supreme Court justice race a year or two ago, and the Democratic candidate, or Democratic-backed candidate, I should say, outraised the Republican-backed candidate, I think something like a 3-2 margin or something like that. So not egregious, but pretty substantial when you're dealing with a state Supreme Court race. And that's something like $30 million to $20 million. And so $50 million for one statewide race just shows the amount of money being thrust into these elections. I mean, it's not that long ago that $50 million would have been the price that a publicly financed candidate would have been expected to run the entire presidential election with. And this is, I don't know, you can add these to your trivia questions to try to figure out, the sort of margins that you used to be able to run a publicly financed presidential election compared to some of the recent Senate, state Supreme Court races, whatever they are, that are just astronomical figures. And just there's so much money churning around for these races.
Yeah, Ned and Steve, off the top of my head, I don't remember the exact number, but here in Ohio, it was something like 470 million spent on the Senate race. Just an astounding amount of money for one seat in the United States Senate.
Yeah, I think it was higher than that, but it was, you know, the highest ever. So, well, Derek, any other observations that you want to share before I ask Tony to go to a trivia question?
I mean, I will say, I think the other side is that the courts moved very expeditiously and effectively in the run up to the election as well. And I think we've talked a little bit about Pennsylvania, but you know, we had hiccups throughout the process. You know, the Republicans were trying to challenge an absentee ballot deadline in Mississippi about whether the ballots could come in up to 3 days after Election Day. And the Fifth Circuit, while it sided with them, said, we're not implementing it now. In fact, we're going to send it back and figure out what happened. So it might have been very disruptive to have that precedent lingering out there, but saying we're not going to implement it now. You had some other changes throughout the United States, and I would say the status quo pretty much held in a lot of places. There wasn't much that you would label as disruptive. And when it came to challenges on Election Day, again, we saw that places like I can't remember if it's Bucks County or Butler County in Pennsylvania, where they had some voting machines that weren't working. Voters were in line and they turned away. They could have voted, but there was a longer line about it, and they would have had to put the ballots in a box before they could have been counted through the machine later in the day. And there was litigation in court, and the court said, we're going to keep the polling place open an extra couple hours. There were bomb threats from Russia in places like Georgia. Some polling places were delayed in their opening by 20 minutes, 30 minutes. The board goes to court. The court says, absolutely, keep these polling places open 20 to 30 minutes. There were poll worker observers from Republicans who wanted to get access in Philadelphia and Milwaukee. And very early on, there was sort of this paranoia like it was 2020 all over again for them, that they were going to be kind of locked out of these rooms. And then negotiations happened with the election officials. They were credentialed observers, and they were able to go in. So there were just lots of places where we saw sort of the ordinary, whether it's negotiation process take place, the ordinary litigation process take place. And these weren't places where there was a lot of contestation, where Republicans or Democrats thought something nefarious was happening. It was a lot of the ordinary stuff that happened. It's not good that we get bomb threats, right? That should be a clear thing. But it's also clear that when there's a problem, we want to have kind of a neutral solution that makes sense. The boards of election were able to go in, seek a remedy. The judicial relief came in very quickly. It was a good thing. So I think the courts were in a very good position in this election and sort of issued pretty typical orders that kind of preserve the status quo and ensure that voters could participate in the political process in ways that were non-disruptive. So, you know, kind of returning to how I opened sort of our conversation, the ordinariness was a good thing, but also the ordinariness of the courts is a good thing.
Great. Well, Tony, you want to remind us of last week's trivia question and then give us a new one?
Yes, Steve. So last week, the trivia question was, how many times in the last 100 years has the victorious presidential ticket featured two lawyers, both the presidential candidate and the vice presidential candidate? And the answer is 10 times. Biden-Harris in 2020, Obama and Biden in 2008 and 2012, Richard Nixon and Spiro Agnew in 68 and 72, Harry Truman and Alvin Barkley in 1948, Franklin Roosevelt and Harry Truman in 44, Franklin Roosevelt and John Nance Garner in 32 and 36, and of course the ticket everybody remembers, the Calvin Coolidge and Charles Dawes ticket in 1924. Those are the 10 times. And next week's trivia question deals with presidential nominations to the Supreme Court. George Washington, of course, as the nation's first president, holds the record for the largest number of successful Supreme Court nominations since he had to staff the court, the first president to do so. He had 11 successful nominations to the U.S. Supreme Court. Trivia question for next week is, which president holds the record for the largest number of unsuccessful Supreme Court nominations. That is, nominations who were rejected by the Senate or who were withdrawn or lapsed. Who has the record for nomination futility?
Very good. Well, we'll chew that one over for a little bit and look forward to getting the answer in our next episode. And until then, let me just thank each of you for being with us, especially Derek. It was great to be able to include you in our conversation today. And we will look forward to getting together again soon. Thanks, everybody, for being here.